So I would like to welcome you on behalf of Garden Court Public Law. My name is Stephanie Harrison. I am introducing this seminar and chairing it along with my colleague Ubah Dirie. We have, I'm very proud and pleased to say, a whole panel, all of women, who are going to talk to you about upholding the rule of law in a time of COVID. I have to say that it's a massive topic, and it was not easy to identify what are the most pressing issues, given that we seem to have a government that is intent in so many different ways in undermining the rule of law. And so we have, as a starter for this topic, which could certainly be the subject of a number of follow-up seminars, 3 topics of significance. They're going to be in order delivered, first of all, by Irene Sabic and Grainne Mellon. Those 2 fabulous public law lawyers are going to talk about the constitutional attack arising from the Internal Markets Bill. We're then going to hear from Sonali, Naik and Kate Aubrey-Johnson, who are looking at the rule of 6. If that's what it still is, it might have changed whilst we've been on air, but is particularly looking at the implications for families and children. And we're going to finally hear from Miranda Butler and Joanne Cecil, again, 2 more excellent public law lawyers who are going to talk about the wide-ranging impacts of COVID on the justice system. So those are the topics. Before we get to those challenging areas of current legal practice, I have to give you the usual patter about everybody being on mute, that there is a chat function in which you can put your comments. There's also a Q&A function, which is where you should ask your questions. And we're particularly keen that this be an interactive session. These are big topics. We're working our way through them and what challenges may arise from them. So we would very much welcome everybody's contributions and thoughts. And if you could put that in the Q&A, Ubah is going to deal with questions at the end. This is being recorded and it may be used for marketing purposes. I hope that that's acceptable to everybody. And I can say that where there are papers and slides that accompany the oral presentations that you're going to hear, they will be provided subsequently next week. So you'll have the written material as well. So all that being said, in the usual way, I'm now going to ask Irene and Grainne to talk about their topic. They're going to divide it up with Irene giving you an outline about why the rule of law is important. We perhaps do need to restate it. Certainly the government needs to understand it. She's going to look at the clauses in the Internal Markets Bill that offend against the rule of law, the nature of the ouster clause, and give us some of her thoughts on the consequences for the rule of law. And Grainne is going to separately look at the international law implications and the impact on the Northern Ireland Protocol, obviously concern there being what that might mean for peace on the island of Ireland. So if I could ask Irene to begin.
Thank you very much, Steph. So thank you all for joining us for this seminar. My name is Irena Sabic, and I will be, as Steph said, speaking to you about the very large topic of the constitutional implications of the Internal Market Bill. Before I say anything, it's worth perhaps raising the fact that this bill has caused profound constitutional and legal controversy. To name but a few issues that have arisen, the head of the GLD immediately resigned, the Treasury Solicitor resigned, the Scottish Parliament has agreed not to consent to the UK Internal Market Bill because, amongst other things, it breaches international law. And earlier this week, the Lords, by an extraordinary majority of 226, voted for a motion that the proposed legislation would undermine the rule of law and damage the reputation of the UK. And this was the biggest defeat to the government by the Lords since the reform of the Lords in 1999. So with this extraordinary background of a crisis, I can't do justice to all the implications of this bill, but I will focus on four. First of all, I will remind ourselves on what is the rule of law and why it's so important. And it may be an obvious point to make, but as Steph says, in the current climate where such a frontal attack is being made on the rule of law, it's worth going back to first principles and reminding ourselves what the rule of law is. It's a constitutional principle which operates on a different level of constitutional significance to any other law that Parliament is correctly under the Constitution empowered to enact. And I went back to Tom Bingham's definition. He was, as all of you will know, Lord Chief Justice. And in his seminal book on the rule of law, he defined it in this way. He said, all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered by the courts. And I found it helpful to have that definition in mind when looking at the offending clauses in the Internal Markets Bill and those that quite explicitly litigate against the rule of law. In their amended format, they are principally clauses 44, 45 and 47, and I'll talk about 47 as the ouster clause in a moment. But looking specifically at clauses 44 and 45, the headline point is that those clauses and the regulations made under them will, statutorily, if this becomes law, have effect from the moment that the UK market bills comes into force, even if it is inconsistent with the law, domestic or international. And that, it seems to me, is in direct contravention of the definition of the rule of law that was set out by Lord Bingham. And the power that is given to ministers to act in contravention of the law is defined in the widest possible terms. To my mind, there is no tool of statutory interpretation to limit the breach of law. Turning next to clause 47, this could be called an ouster clause, but it's an ouster clause like no other. The Attorney General has called it a notwithstanding provision. I tend to think of it, and the more I looked at it, I tend to think of it as a superiority clause, and that seems to me to tally with the attitude of the current government. And the reason I say it's a superiority clause is because it puts the provisions of this bill and the regulations that are made under it above the law. That's explicitly what it says. And that, to my mind, is the antithesis of the rule of law. That's the general point about the superiority clause. On the specific points, there are two features of this clause that are extraordinary. The first is that direct effect of EU law is simply out. And this is in clear breach of the withdrawal agreement, which provides that certain provisions of the withdrawal agreement shall produce in the UK the same effects as those effects within the Union and its member states. Clause 47 unequivocally breaches this part of the withdrawal agreement. Direct effect is out if it's inconsistent with the Internal Markets Bill. Secondly, judicial review. Clause 47 provides that regulations have effect, notwithstanding any relevant international or domestic law. And what that does is immunises secondary legislation to an unprecedented extent, potentially excluding any judicial review on conventional domestic law or human rights grounds. And further still, again extraordinarily, it obliges the courts to treat secondary legislation as if it were primary legislation for the purpose of the Human Rights Act, and therefore disempowering the courts from striking down secondary legislation, so that all that the court could do is issue a declaration of incompatibility. What does that mean in domestic law context? Well, it would potentially mean that state aid, which is contingent on, for example, support for a political party, is lawful, that the exclusion of the Bribery Act is lawful, that the imposition of discriminatory charge or secret guidance would all be immune from challenge. And these are points that have been made by Jessica Simon, QC. This superiority clause is a carte blanche for any breach of law which is given to a minister. And it also has an important bearing on access to justice if it excludes judicial review challenges. And access to justice, as we all know, is a fundamental component of the rule of law. It's unclear how the courts will deal with this ouster or superiority clause. Professor Mark Elliott has offered two potential roadmaps for the courts in dealing with it. One would be in line with the anisminic principle that if regulations made under clauses 44 or 45 are out with conventional public law principles, then they shouldn't be considered to have been made under those provisions at all. Second way of dealing with the superiority clause would be to follow the privacy international principle and to simply say that Parliament cannot entirely oust judicial review. What is clear is that there is, if this law is passed, going to be a showdown in the courts. And I just pose the question of how this is going to play out in the context of the current culture and political climate, where activist lawyers are under attack and judges are accused of activism too. I know I'm maybe running out of time, but I just want to end with a thought as to what is left of the Constitution and the rule of law. And it's a big question. I can't answer it. But what I can say is that, to my mind, it's clear that this is legislation which legislates quite explicitly against the rule of law. And I think we are in danger of potentially being naive and supposing that we are immune from authoritarianism, the rule of law collapse, and totalitarian systems. And I say this as somebody who has experienced a complete breakdown of the rule of law, coming from a country, former Yugoslavia, that descended into a civil war. And to my mind, a large part of the reasoning why that was enabled to happen was the breakdown of the rule of law. And I would suggest that those in power would do well to be reminded of the final destination for a government or a state which actively legislates against the rule of law. I'll pause there and hand over to Grainne.
Thank you, Irena. And I can only echo how important it is that I think we're having this conversation, and what an obvious place to start when we're talking about challenges to the rule of law in recent months. There have, as Irena has set out, been huge concerns about the government's plan to break international law in what now feels to be the quote that we'll all remember, in a specific and limited way. And it has huge ramifications in a whole range of ways for the UK's place in the world, for Brexit, the constitutional implications, some of which Irena has touched on. But I want to talk about some of the international law implications, and also briefly in terms of the implications on Northern Ireland. And the point that I want to make is that I think that the consequences of this, in terms of the international consequences, are much more than simple tut-tutting. And I also want to reject the proposition, which I have heard mentioned in the discussions around this bill, that states violate international law regularly, that somehow international law is of less effect or consequences than other types of law. It's not true. And also the nature of the proposal in this piece of legislation really is remarkable, because it's a preemptive breach. What's set out in the legislation is that it gives the government powers to violate the withdrawal agreement if they need it. They don't know that they need it. They're simply setting out their stall in advance, and that is what makes it absolutely remarkable, not least because there is provision within the withdrawal agreement to resolve any conflicts that arise. So I'm going to set out four main concerns, and let me tell you, it was quite a tough job to whittle them down to that. So the first one is about that I think it undermines, this act alone of laying this legislation before the Commons undermines the ability of the UK to negotiate treaties. And I'm talking beyond Brexit here. In the years to come, the UK is going to have to negotiate any number of treaties with any number of countries. How would you feel if you were sitting down opposite a government who just a number of months after signing a treaty decided, and indeed winning an election off the back of it, decided to pass domestic legislation undermining it? International law and treaties between nations are grounded on trust and confidence, and I think there is a real issue in treaty negotiation as a result of this act, whether political tactics or otherwise. It poses a real concern. Secondly, it undermines the country's ability to hold others to account when they violate international law. All you have to do is look at the Foreign and Commonwealth's Twitter page to see still that there are endless tweets about the government in a whole range of countries, the rule of law in Hong Kong, freedom of expression in Turkey, China, and that is all well and good, and indeed work that we support, and certainly in the Bar Human Rights Committee, which I'm involved in, work which we are always trying to promote. But it makes our job much more difficult, and it makes the Foreign Office jobs much more difficult. How can you go to another country and promote the rule of law and avoid them saying to you, well, you're telling us this, but you're doing something else yourself? How do you avoid the label of hypocrisy if you have laid a piece of legislation before the Commons, which, as Irena has set out, preemptively and very blatantly in a barefaced way proposes to violate international law? The third point is about a softer point, really, about the place in the world and also the legal system as a whole, because I think that our profession, solicitors, barristers, judges, mediators, do rely on the reputation that the legal system as a whole in this country is one which can be trusted, which is fair, has integrity. And I think that there's a risk of all of this seeping through and undermining that reputation. And it's a point made, I think, most effectively in a quite remarkable intervention by the Chief Justice of Northern Ireland, Sir Declan Morgan, who is the current Chief Justice, and who took it upon himself to give an interview when this piece of legislation was introduced, saying that it risks undermining trust in the rule of law and the administrative justice, and indeed in the legal profession. So I think there is a concern. I think the position of the law officers also raises a concern as to the approach to this bill. But I also think, on the other hand, we can take some comfort from just how the professions as a whole have responded. The resignations that Irena mentioned, the Bar Council and the Law Society have made very strong statements calling for the removal of these clauses. Lord Neuberger, who has contributed extensively to a number of IBA debates, which I know many of you will have seen. And there has been a unity in the profession across the board and a real call that this is not a political issue, that this is not a Brexit issue, that this is a rule of law issue. And I think our role as lawyers is to make that point repeatedly. And I think issues surrounding the rule of law are issues for us. And so when we're thinking about the issue of how do we uphold the rule of law, I suppose one point that I would make would be to remind us all that we have a part to play in that. The fourth and final point that I want to make is about Northern Ireland, because we've talked about the international law issues that arise from the legislation or the bill even, but and the ways in which there is a proposal to breach international law. But what is also important is what is the apparent justification for this preemptive breach. And we are told eventually that the reason for it was, in fact, to protect the Good Friday Agreement and the Northern Ireland peace process, when in fact I think anyone would accept on a proper analysis that it is likely to have the opposite effect. And we remember, of course, that the Good Friday Agreement is also an international treaty, which the government is also bound by and in fact is a co-guarantor of. And it is using, in fact, this international treaty in quite a selective and partisan way to justify the breach of another international treaty. And the justification is a further compounding factor which should cause alarm in terms of the rule of law. And even setting aside the rule of law issues, it's an unfortunate decision to make, I think, going into a very sensitive time in the Brexit negotiations, particularly for Northern Ireland. And I really just want to end with some broader reflections, which Irena has also picked up on, that what we are seeing in recent months are, I think, more challenges to the rule of law. I think it's appropriate to draw parallels that this is happening in other countries too, in other European countries, and that it's very useful to make sure that we pause and really acknowledge the reality of that. I think what has been interesting in discussions about the Internal Markets Bill is there have been questions about, well, is this a once-off because of Brexit? Is this really just tactics, political negotiation tactics? Whether it is or not, I think probably Irena and I agree that it still poses a direct and very serious challenge to the rule of law. But also and what I hope we can come to discuss throughout the evening event is that this does feed into a bigger picture about accountability and the separation of powers, about activist lawyers and enemies of the people, also about the way in which law and decisions are made, about consultation and about delegated legislation. In relation to this bill, of course, we heard about the specific and limited breach in Parliament long before we knew anything about the detail. And it may also represent a move away from an international legal order based on rules, or at the very least, I think that's a question that's worth raising. So really just to conclude, I would reiterate that this is not a specific and limited breach, however the government may wish to define it. It is huge and it has far-reaching consequences domestically, constitutionally, internationally, and for Northern Ireland. And I agree with Irena's analysis that it can be a very slippery slope once, particularly in this barefaced way, there is a proposal to breach the rule of law in this way. And I would conclude really just by saying that in looking at the question of how we uphold the rule of law, we as lawyers have a particular responsibility in that, and we can be proud of the way our community has responded so far and continue to make arguments about this bill and why it should not become an act with the controversial clauses remaining in it. So thank you very much.
Thank you very much, Irena and Grainne. Obviously, both contributions indicating a very blatant and direct threat to fundamental principles of our Constitution. We do have some questions arising from those presentations. We'll take them all at the end, all in one go. We are now going to hear from Sonali Naik and Kate Aubrey-Johnson on implications for fundamental rights that have occurred not so much directly and in a concerted political way, but essentially by default. Both are going to look at how the COVID emergency restrictions have impacted on the previously well-established and well fought for protections for children, in particular looking at children with additional disadvantages who may be disabled, who have special educational needs, and how they have been impacted on the very significant restrictions on ordinary social life that we've all got somewhat used to. Both have a strong aspect of their practices focusing on the rights of children. I'm sure you're familiar with Sonali's work in the immigration context, and Kate focuses much more on criminal justice. So they will look at this topic from their informed perspectives, and I think Sonali is going to go first.
Actually, sorry, I think Kate, sorry, swapped on.
Okay, sorry. Well, I think, but I'm wrong. Kate is going to go first.
Thank you so much, Steph. So we're going to use some slides. So thank you for that introduction, and thank you for having us today. So we were talking about the threats to the rule of law, and at the time there was a petition where people had signed to challenge the rule of six, which was impacting the rights of children and families, and it made us think about how have we got here, and does this represent a challenge to the rule of law? There have been many ways in which children's rights have been impacted, the school closures, the rights of children and young adults with autism, children with mothers in prison, children with special educational needs. And there is a wide disparity. We talked about all being in the same boat when the schools were closed, and there were very tight lockdown restrictions on our lives. But of course, we were all restricted in the same way, but we weren't in the same boat. And there has been a wide difference in how these restrictions have impacted children's access to education. So what is the legislation that has enabled the restrictions following the global health pandemic caused by the coronavirus? So the primary legislation is the Coronavirus Act, but we also have seen secondary legislation that has been issued under both the Public Health Control of Disease Acts and the Civil Contingency Act. The Coronavirus Act came into force very quickly. It was fast-tracked through Parliament and in fact was debated in a single day. The Act aims to support the government in doing the following: increasing the available health and social care workforce, easing the burden on frontline staff, containing and slowing the virus, and managing the deceased with respect and dignity, as well as supporting people. The implementation came largely through delegated legislation, and this has been done through the affirmative resolution procedure. Usually, and the normal procedure for doing so in the convention is to lay it before Parliament with 21 days in order that it can come under some scrutiny. But in fact, the Hansard Society reported in July that 97 of the 130 pieces of delegated legislation had breached that 21-day convention. So how does the Act provide in relation to education? Well, it provided a power to require or direct the temporary closure of educational institutions and registered childcare providers, power to make specified types of directions in connection with the running of education, and the power to disapply or vary specified existing requirements contained in or arising out of education and or childcare legislation. The Act, in its explanatory notes, talks about the particular challenges and risks to those operating in an educational childcare context, and acknowledges the harmful effect that any break in education may have on a young person's development. And it talked about what is in the best interests of those in education arena will vary according to the level of risk which presents itself in a particular context at a particular time. And so the Act sought to provide a suite of powers so that the government could react flexibly and manage different levels of risk. In addition to the Coronavirus Act, as I said, there were also powers that were issued under the Health Protection Act, and the powers, in fact, to restrict gatherings, what have been nicknamed the Rule of Six, that prevent us from gathering in no more than 6 people, although it now depends on the relevant alert level in your area as to what the restrictions are, came in as delegated legislation. And now I'm going to turn to Sonali, who's going to look at the statement of compatibility that was issued when the Coronavirus Act was brought into force.
Thank you. I don't know, does that mean you can still see me? I hope so. And it doesn't really matter if you can't see me and you see Kate. And also Kate's going to operate the slides at her end, I think, so that's helpful. It may come as a surprise to you. It came as a little bit of a surprise to me that actually the Secretary of State had made a statement of compatibility in respect of the Coronavirus Act, and that, in fact, a lengthy statement which stated that in his view the provisions of the coronavirus bill as it was are compatible with convention rights. And importantly, and it's really, this will inform how any challenges to the regulations and or the Act itself are brought in the future with reference to what's set out here. And it was specifically addressed to the Joint Committee on Human Rights, of which we will speak a little more when we talk about their more recent report. But the government emphasised that it's important to note that once enacted, the lifespan of this Act and the measures in it are limited, and it will only be enforced for as long as is necessary to deal with coronavirus. And therefore, whenever the analysis in the body of the report covers interference with a qualified right, this is an important consideration which goes to the proportionality of the measure. So all the principles with which we are very familiar, but concentrated in that statement of principle, so-called principle anyway, by the government in that statement. They recognise in paragraph 5 of the statement that there's a potential for the cumulative impact of provisions on certain people's qualified rights, but they consider that there's an overriding public health emergency which presents a very strong justification for any potential interferences caused by the bill's provisions, whether it's by one clause or multiple clauses. So that's the important context which the government has asserted. And you'll see later on, we'll note that the courts have been relatively reluctant to get involved and during the initial lockdown phase and during the early parts of the pandemic. But as things go along, there are opportunities to review how that is working in practice, and also, more importantly, following the initial 6-month extension period, how that's going to be going forward. So if we could look at the next slide, slide 10. So the recent Joint Committee for Human Rights report is really critical of the government's response on coronavirus across the board, and it's really worth reading to see what opportunities for litigation that may provide. In ordinary times, the JCHR report in terms of denial of access to justice, a denial of right to children education, healthcare, and what the impact on children in prison or in detention would ordinarily present huge litigation opportunities. And I use that word advisedly. I'm not obviously trying to sound like an activist lawyer. I'm saying this is our job to hold the government to account. So it's important to identify looking at the coronavirus, looking at the JCHR report on the coronavirus, what the focuses are. The JCHR recognised that the central aim of the government was to protect lives, and they recognised that the obligation under Article 2 of the ECHR. But the JCHR say that some groups have been particularly at risk from COVID, that they identify that the impact has been disproportionate in death terms on certain communities, and that's obviously includes children. But they specifically identify that in the context of the lockdown regulations that are, and the broad use of the powers, they've had, not only has their impact been huge, but there's been a huge amount of confusion over the status, interpretation of the guidance and the relationship between guidance and law. And that then has an impact on policing, it has an impact on whether people can challenge convictions, and it absolutely, what they emphasise is it in their summary, is that given the speed and the frequency with which the national and local lockdown laws change, it's actually very difficult for people to keep on top of what's legally required of them, what's reasonably expected of them, what their rights are, and how they can enforce their rights. And that's a critical part of probably everyone's experience here as a human, as well as their experience as a lawyer in this particular context. So they specifically identify that the closure of schools engages the rights of children, including their right to education. And that obviously, as Kate mentioned, it will have different impacts on different children, but that the government must ensure that the inequalities aren't made any worse during this period. And they already identify in this report that school closures have particularly impacted on those with special educational needs and disabilities, and that the government must address those barriers before they identify what they're going to do in terms of those children returning to school. So they also emphasise that the government must be transparent in terms of its timings of decisions to go into and out of lockdown, to justify their decisions as necessary and proportionate, and they emphasise based on relevant scientific evidence with the precautionary approach to minimising the risk to life. Again, all the familiar principles that we as lawyers use in our everyday representations to government bodies, and our representations to local authorities and to other public authorities. And it's emphasised there that nothing has changed as a matter of law and principle. The real question will obviously come in terms of how that plays out in justification. And the JCHR conclude in their summary by saying Parliament is the right place for the government to announce its decisions. This is going back to Kate's point about the relative scrutiny of legislation and how far that is being extended. And this is particularly so, they emphasise, where emergency powers are being used. And whilst the use of emergency powers, including fast-track legislation and affirmative statutory instruments, may have been justified in exceptional circumstances, which we were in March, they say the use of emergency procedures must be limited to what is absolutely necessary, especially when human rights are at stake. So that lays the framework, we say, for looking at those principles in the context of the children's rights of access to education, the decisions in relation to care, in relation to detention and other restrictions on access to services. Now, we know that the courts have been reluctant to intervene. I just wanted to go to the next, before I come to the courts, can we go to slide 11? Just specifically, before we come back to what remedies are available, looking at the children and right to education, what the JCHR identified was that instead of issuing a direction under the Coronavirus Act to close educational establishments and properly justifying the need to close schools, the government actually did this through press announcements, and really what they did was they encouraged schools not to allow pupils to attend except in certain groups, for example, key worker children and parents, and encourage parents not to send their children to school. And so the JCHR said that we consider the measures are likely to affect human rights should have a proper legal basis, be properly justified, and not be announced through a press notice. Again, that's unsurprising in ordinary times. It's actually not surprising in the time we're living in now, and we should not accept it as being consistent with the rule of law unless it is absolutely necessary in an emergency context. So I think that we've got some food for thought and legal challenge there. And critically, the legal status of such measures should be communicated so that parents and children know on what basis they're being denied access to school. Otherwise, to do so raises a real question under the rule of law and human rights concerns. And that, I think, is absolutely critical. I don't know whether anybody got a letter or an email telling them why they or their child was not allowed to attend school. And in fact, I didn't see any communications like that. And it's really important that we put the onus back onto the public authority to act lawfully and consistently and within their powers. Can we just go to the next slide, 12? This is again the emphasis that the JCHR put on the generic problems with the lockdown regulations, which then specifically apply in all the contexts that we are talking about in relation to children, the rule of six and so on, which is that there isn't a clarity between rules and guidance. There isn't certainty as to what's criminal and what isn't. The regulations aren't accessible. People don't know where to find them. They're not put to them. You have to look for them. And there aren't sufficient warnings about changes in the law. And those regulations should have flexibility in respect to some individual sets of circumstances. They reference specifically protests, but they also reference other gatherings, including family gatherings. I just think, in view of the time, I wonder if we could just skip to slide 16. Might just be a bit of a. I think we're not going to get through our so many slides. Thank you. So, just before the court, we asked the JCHR has asked the government to respond, and there hasn't been any specific response yet, apart from some ministerial statements, which is effectively asserting that they wanted that the rule of six achieved a balance, and that was the best that the government could come up with. But ordinarily, when we are scrutinising legislation, legislation is scrutinised in Parliament, both primary and secondary. And ordinarily we'd have a consultation period before we had legislation, and subsequently legislation would be tested through the courts, and then that's how the balance of our power effectively is maintained. There's been relatively little consideration by the courts in relation to scrutiny of the coronavirus legislation. Just put up some of the most recent cases on the screen there. And I won't have the last one is concerned with, well, in fact, the court found that Christian Concern didn't have standing to bring as victim status under the Human Rights Act. I think there's a missing line there. But the key case there is for the purposes which we're talking today, is the Shaw case, which was unsuccessful. It was a rolled up judicial review, I think that's right, on the challenge to the modifications and obligations of local authorities to make provision for children with special educational needs and disabilities. I'm just checking my time. If we could just go to the next slide, which is slide 18, I think. So how would we challenge restrictions? We obviously in the ordinary way would seek a declaration of incompatibility on primary legislation, seek a quashing order with regard to secondary legislation, which is actually, as we can see, what most of these issues are concerned with, or even more so policy based. If there's prosecutions, you might want to think about a Boddington defence as to whether or not, in fact, the appropriate criminal offence was in fact enacted through appropriate legislation with the relevant vires. I just, on the next slide, because I've got 1 minute or probably no minutes, I just wanted to remind ourselves what the ordinary proportionality test is, even in the sort of national security context. And that test is still the applicable test from when we are holding the government to account with regard to those principles, whether the objective is sufficiently justified, important to justify a limitation on a fundamental right, is it rationally connected to the objective? Could a less intrusive measure have been used? That's the key here. And then the balance. So that's what we want to do going forwards, is to look at the relevant regulations that have been applied to children and families and look at what the justification is. What's the evidence base for it? And that would hold the government to account. So the final, that's what we say is the way in which the litigation can be successful, or at least try to encourage an appropriate scrutiny. It may be that the litigation isn't ultimately successful because the court will apply a sort of margin of appreciation in this context. But the reality is that is the process that should be gone through, and the government should be required to produce the evidence base to justify the conclusion that they have reached. Thank you. I think I've gone over time, sorry.
Thank you very much, Sonali and Kate. Again, we couldn't ever have imagined the wide-ranging ramifications that there would be when these measures were introduced, focused as everybody was on the imperative of protecting life and vulnerable people, and obviously our vital public services. And I think that we all sleepwalked into what is now turning out to be a very serious impact on very many aspects of what were previously our ordinary enjoyment of fundamental rights. And I think there's no area that hasn't been more significantly affected than the civil and criminal justice systems. And this is the last topic for tonight's discussion. We're lucky to have Miranda Butler, who has a wide-ranging public law practice covering mainly civil litigation, as well as Joe Cecil, who also combines public law with serious criminal cases. And they are going to have a look at how the drastic changes that have come about as a result of the COVID restrictions have impacted on our justice system. They're going to look at factors such as time limits, custody time limits, changes to court's hours, the impact on access to justice of remote hearings, and what this may mean going forward, since it's quite clear that they're with us for some time to come. So I hope I've got it right this time. Miranda is going to speak first.
You've got it exactly right, Steph. Many thanks for that introduction. And I think Steph has characteristically hit the nail on the head by appreciating the concern about sleepwalking into some pretty drastic changes as a result of what were meant actually to be temporary changes. I'm going to start by going back further than March 2020 and those apparently initial changes, though. I'm going to start by talking about what the civil justice landscape looked like pre-COVID. I appreciate that many of you who are listening to this talk will have been working in the civil justice landscape long before LASPO came along. But it's worth recognising in any discussion about the impact of changes on the civil justice system, what a radical effect LASPO has had. We all know that it came into effect in April 2013, slashing many areas of civil legal aid. I've mentioned some, but not all of the areas that were taken out of scope for legal aid on this slide. And we can see how diverse and wide-ranging they were. I've also noted that, of course, the financial eligibility criteria were tightened as a result of LASPO. And the effect of that was a huge drop in the number of civil claims being brought on legal aid. The statistic that you've got in front of you on that slide comes from the MOJ itself, noting that there was a 74% drop in civil claims funded by legal aid between 2012 to 13 and 2016 to 17, which was even greater than what the government's own estimates at the time of LASPO thought there might be. And that precursor to COVID already amounted to a significant barrier to access to the courts and vindication of the rule of law for many people. There were also, of course, significant effects to court funding, including in the civil courts, and as I'm sure Joe will mention in the criminal context too. We've all seen in our day-to-day practice the crumbling court estate, but relevantly, the fact that Chris Grayling, when he was Lord Chancellor, was willing to lean in so hard for cuts to the Justice Department meant that court modernisation couldn't properly happen. We couldn't make sure that we had the kind of civil court system, especially for day-to-day legal aid cases where significant issues are at stake, that would allow for effective remote participation. So now I'm going to come forward in time and I'm going to ask what happens when austerity meets a pandemic. And my notes for this slide just say chaos. I'm sure we all saw that in our own practice. I think my reference here to widespread adjournments and delays is perhaps something of a euphemism. Huge numbers of cases, including cases raising urgent issues, were simply postponed. And whilst judges in most cases attempted to be pragmatic, whilst the Courts and Tribunal Service were keen to facilitate protecting people, the immediate impact of COVID was that many people were unable to have their case heard in a timely way. And I'm here going to be an absolute cliche and roll out, of course, the famous idiom that justice delayed is justice denied. And for many of our clients, that's what COVID meant. However, I'm speaking here as a legal aid practitioner. And what the Civil Justice Council's rapid review in May 2020 found was that there was a divide in practice between certain courts, I'm thinking here particularly the higher courts and the commercial court, that are very well funded, that had live streaming, that had remote hearings, that had proper technology in place, and who were able to transition fairly swiftly and fairly effectively. And the lower courts, the Immigration Tribunal, SEN tribunals, we're thinking about MAGS courts, county courts. All of these courts had suffered from years and years of cuts, and it meant that they simply weren't ready to transition to a mostly online way of working. There are two significant rule of law issues that arise that I'm going to focus on in my limited time. Firstly, there's the question of how open justice is affected during this time. I've referred here to the coronavirus practice direction that came in, and that attempted to be a pragmatic way of encouraging courts to broadcast hearings where they could, to involve the media where they could, but also to sit in private when that wasn't reasonably feasible. However, the focus of this practice direction, the focus of many courts, has been to facilitate open justice by allowing the media to participate. And as I've noted here, access to the courts for the media is not open justice. And what the CJC and other bodies have found is that there have been significant problems for members of the public who've wanted to participate in hearings about learning when they're going to be taking place and then attending them remotely. So that presents a significant rule of law problem. I also am going to suggest it presents a significant rule of law opportunity. Open justice could be meaningfully facilitated widespread use of remote hearings that were properly available online, where people could learn about them in advance and attend them with ease. If that were the case, it would actually mean a greater system of open justice than before. The second issue for the rule of law principally is access to legal advice and representation. I've quoted here from a Law Society report that noted that not only were many people literally shut out of court, particularly some of the most vulnerable and institutionalized people in our society were unable to access representation or to participate meaningfully in hearings as a result of the move to online only. The Law Society focuses on people in care, in prisons, in immigration detention, in mental health settings. And often these people do not have adequate technology, nor has the Ministry of Justice provided them with adequate technology to engage meaningfully in hearings or even to seek the advice that would get them to that stage. And as is noted here, this is an essential element of scrutiny. And going back to Sonali's talk and Kate's talk, they were, of course, emphasising that many of these people have been additionally vulnerable during this time. Finally, before I run out of time, I'm going to talk about what happens next. The House of Commons Justice Select Committee's report on the impact of COVID on courts concludes that COVID shouldn't be used as an excuse for bringing in permanent changes without prior consultation and suitable evaluation of their effects. That has to be our guiding principle going forward. And we as lawyers, and I'm speaking for myself here as well as everyone else, mustn't allow convenience and the ease of remote hearings to mean that we fail to suitably identify the shortcomings, particularly for the kind of people that we often represent. I've referred here, for instance, to the radical changes that took place in the upper tribunal, the move to decisions being presumptively made on the papers, which has, I understand the judicial review challenge to that has finished today in the High Court. That's one of many examples of a radical shift that may well stay in place after coronavirus is merely a memory. And we need to keep identifying these problems, identifying where there are opportunities, and identifying where something is no longer strictly necessary as a result of coronavirus, and pushing for it to be repealed. Thank you very much. I think that's my time. I'll hand over to Jo now.
Thanks, Miranda. Just going to share my screen, hopefully, she says. Perfect. So I'm here to discuss today the impact of COVID on the criminal justice system, and many of the themes that Miranda and others have already touched upon really flow through the impact within the criminal justice system as well as the civil justice system, and you'll see that there are concerns that effectively mirror each other, which is perhaps unsurprising. The first aspect I want to touch upon is just the pre-COVID criminal justice landscape. A little bit like civil, a system that can only be described as being in crisis, a decaying court estate, a sell-off of courts across the country, cuts upon cuts upon cuts, both in terms of the legal aid provision, but also just in terms of the actual resourcing of by HMCTS of the system. Huge fragility in the provider market, and I'm sure you don't need me to tell you about the ageing population, for example, of criminal defence solicitors, or the legal aid deserts that exist in crime and are increasing on a daily basis. And perhaps importantly, for the purpose of what I'm going to talk about primarily today, which is the government's response in relation to trials and the lack thereof of trials, significant delays within the criminal justice system. And so delay was something that was effectively routine within the criminal justice system prior to COVID. Of course, then what happened was COVID hit. And I've just headlined out a couple of issues here. Prisons, as has already been touched upon by Kate, conditions of detention, access to family, prisons obviously being significantly under-resourced, access to clients in custody. Those issues continue to, unfortunately, provide significant barriers to us all. Certainly you'll have seen some appointments aren't until December of this year, and so on and so forth. How you're supposed to prepare for a trial or get things progressing in that sense is beyond me. Significant issues in relation to the technology that was being deployed, all sorts of different technological platforms. What was notable, however, was the commercial and corporate courts could get up and running in the chancery divisions, but criminal courts were just left floundering. Remote hearings. We've already heard a little bit about the issues regarding access to justice, effective participation, and of course, open justice. But for the criminal justice system, one of the biggest challenges has been in the Crown Courts and in trials, jury trials, for relatively obvious reasons, owing to the number of participants that you have to have in a courtroom at any one time to conduct a jury trial. It's fair to say that despite every effort by the profession, and I say professions, I should say, very limited resources were then put into the criminal justice system. Instead, effectively patch solutions were sought to be found. So remote participation, we've had a trial whereby if defendants are beamed in from the prison, we've had a couple of trials whereby 2 courts are being utilised. We're finally getting some perspecs, which, as a colleague of mine remarked, Primark had them from the outset. I think practically every coffee shop I've walked into has had them from more or less the outset, but for whatever reason, we couldn't manage that. We also couldn't manage basic facilities. We were asking for hand sanitizer. We were told, well, you've got washing facilities at court, and it had to be pointed out that actually we don't have hot water. We often don't even have cold running water. And if you've seen the states of our current courts in the criminal system. Then we moved obviously back to HMCTS's pet pilot project, which pops its head up every so often. Now called extended operating hours, previously flexible operating hours, more or less the same thing. We've had pilot after pilot in this regard, and yet once again that seems to be the HMCTS's answer to the problem, not to resource courts properly, but let's just try and extend the working day and have a few evening courtrooms. Nightingale courts. Well, we saw the fairly impressive response in relation to Nightingale hospitals. Courts somewhat lacking, some might say. So we now have effectively 8 courtrooms up and running, the majority of which cannot hear trials with defendants in custody. That, unfortunately, is the biggest challenge for us in the criminal justice sphere right now. And so we come on then to the government's next response. First of all, we heard about judge-only trials. Then we heard about judges sitting with 2 magistrates. And all of these really were the forerunners to what then came into force, which is the extension to custody time limits. So custody time limits, I'm not going to go through that in any great detail, only because of the length of time that we've got, but essentially they limit the length of pre-trial detention. Its purpose is to protect the liberty of the citizen, assumed obviously, one might say, to be not guilty at that precise moment in time. And I've set out where the relevant provisions can be found. Importantly, the actual limits themselves are set down within the regulations and are designated by the statutory instrument, and that has an important impact when it comes to looking at what's happening at the moment, and of course the broader landscape of how the government are responding to the COVID crisis, which generally means the laying, as we all know, of statutory instruments absent any real parliamentary oversight. And so just to give a bit of background, previously, and I'm going to concentrate on the Crown Court, we were looking at 6 months as a custody time limit, after which, upon application, it could be extended. The relevant test, and this is relevant for our discussion today, was firstly that there was another good and sufficient cause for extension, and that secondly, the prosecution had acted with all due diligence and expedition. And it's really the first of those that engages the COVID issues that we're all seeing. And what has always been relevant to that assessment is the availability of a courtroom, and certainly in relation to courts, were a court not available at a court centre, then we had to look at other court centres around the country. So jury trials were suspended. This is really going to be a complete whistle-stop tour. Applications were made to extend CTLs. They were initially granted. There was a protocol that was brought into force, said not to have an impact on individuals' decision-making, but ultimately was very much, well, this is a just and sufficient cause, COVID in itself, the pandemic. And of course, one can understand that when it was introduced, which was back in April, effectively the beginning of it. That was withdrawn at the beginning of September, and then followed by the laying of the statutory instrument. It only applies to cases from the 28th of September, but it extends that period of time now to 8 months. Effectively justified on the basis of COVID. I'm not going to go through it in detail, but you'll all be well aware that actually the delays that we are experiencing were pre-COVID, and COVID, frankly, is being used as a smokescreen as a result instead of sitting days. And frankly, it's the very definition of irrational to import more delay into a scheme that is said to be trying to limit delay. So then what we had was increasing concerns because judges began to refuse those applications to extend. There was a relatively explosive ruling down in Woolwich Crown Court, which alleged not only that there was improper pressure being applied by the senior judiciary, but also alleged irregular listing practices for CTLs. Ultimately, it all came down to a failure by the government to resource trials properly. So was there any impact assessment conducted in relation to the CTLs? Short answer is no, and I've set out the explanatory note there. There was also the failure to consult the Children's Commissioner. Now, why is that important in the context of CTLs? Because, of course, there is an impact, and the impact is fairly acute. So first of all, you have the impact upon the innocent, with over 3,000 people being acquitted, and now obviously potentially spending significantly longer times in remand if those proportions follow through as they generally do. Children, some 45% of children were on remand compared to 37% of adults. So we see already a disproportionate impact upon children. And as we can see, almost half of those, even when they were convicted, did not receive that immediate sentence of imprisonment. And we then have the impact upon those who self-harm and vulnerable categories and mental health. And moreover, what we also very starkly see are the implications in relation to BAME and BAME communities. And so effectively, and I'm going to scoop through these aspects at the moment because you'll all have the handout in due course. You may have seen a potential legal challenge I'm involved in along with others from Doughty Street, and that involves the Howard League, Liberty and Just for Kids, who wrote to the various ministers setting out their concerns. Not a pre-action letter, this was setting out the concerns and asking about impact assessments and seeking disclosure. In short, after some to-ing and fro-ing, the equality statement has now been published, and somewhat unsurprisingly, it accepts that there's indirect discrimination, that BAME in children are disproportionately impacted, and of course, one then has to look at the impact on BAME children. And instead, what they say is that they state that it's justified because of the exceptional circumstances of the pandemic. And so it's a fairly bold assertion that we have a statutory instrument that on its face the government simply imports yet another aspect of discrimination into our criminal justice system with already all of the challenges it's facing, and certainly somewhat disappointing in light of the Black Lives Matter movement. So I hope that's been a bit of a whistle-stop tour. There's a couple of slides then on extended operating hours, as I've said, aka FOH. We've been here before, we're going round in circles. But that concludes ultimately my talk. As you can imagine, all of us can probably talk for hours on all of the problems that we're facing, but also all of the potential challenges. And there are many, and again, not seeking to be an activist lawyer, but really we do have to challenge some of these things. Thank you very much.
So that's our final contribution. We're going to address your questions, and Ubah, my colleague, is going to deal with the questions and put them to the panelists, and then I will have the task of trying to draw this to some kind of conclusion.
Perfect. Thank you very much, Steph. And I think this kind of seminar has been so interesting. And because of how fluid and rapidly changing everything has been, we could probably have this seminar every month for the next 10 months, probably, or at least until the end. But the first question that has been put in the Q&A, I think, is probably for Irena. And it says, thank you for this interesting session. Can I ask, if JR could be prevented, are there any administrative or preventative steps that could be taken effectively against the legislation to get 47 to struck out or redrafted?
Thank you very much. Thank you for your question. I think it's a really interesting question. If we as lawyers are being asked what can we do, at the moment there is no remedy because it isn't law. That's what seems to me to be plain. There is much we can do as upholders of the rule of law to draw to the government's attention how fundamentally problematic in terms of our constitution and the rule of law clause 47 is. You will be aware that the government has made significant amendments to the bill, and to my mind they haven't made the position any clearer. So in summary, when the bill was first published, it seemed obvious that JR was out. Since then, there have been amendments which allude to the possibility of judicial review. And in fact, the government has published an ECHR memorandum which explicitly states that judicial review that clause 47 will not operate to oust judicial review. Well, that's fine as a matter of words, but how do those words translate into practice, and how do they square with the provisions of clause 44 and 45, which, as we've previously discussed, say in plain terms that they will have the effect, notwithstanding any relevant international or domestic law inconsistency. So it's a smoke and mirrors type situation, and that's how it's been described by leading academics. And that's why there's a showdown, in my mind, between the executive and the government looming. And to come back to your question, I don't know if others would disagree, but I think at this stage, we can just sit and watch and comment on how this plays out for the rule of law.
Thank you very much for that, Irena. The next question I think is probably maybe for Grainne, and it asks which country. So you said, Grainne, in your bit that there are countries that we're seeing more of a trend where we compare the UK to other countries where we're seeing a similar trend kind of occurring. So the question is, which country do you think is leading the way in terms of upholding the rule of law? So maybe giving a positive shout out to countries that we could be looking at in their response to COVID-19 in the way that it protects lives and the most vulnerable in society.
I think that's a really good question, and I don't know which countries have led the way. Obviously, we hear much more about the ones that haven't. I think there has been some positive feedback, obviously, in relation to New Zealand and the Netherlands. But I think if we're looking for positives from COVID-19, and we do obviously need some glimmer of hope at the minute, I think while obviously we've heard that especially lockdown has impacted those who need justice the most, have suffered the most, disabled people, children, women are most at risk. But I think there has been some positives. I mean, for me, one of them is it shows that change is possible. I mean, a legal system which we would have all thought was so antiquated has managed to make radical, quick reform in a way which we would never previously have understood. And I'm thinking including in countries like Turkey, where they released hundreds and hundreds of prisoners, fairly quickly in a way which would have previously been unprecedented. Obviously, here we had many asylum seekers accommodated in a way which we simply wouldn't otherwise have seen. So I think that's a positive. I think the racial reckoning that followed in light of the George Floyd murder has helped other countries address the need for a proper functioning, accountable police service. And I think those debates are happening now. We're seeing them in India and Georgia and a whole range of countries. So I couldn't describe it as a positive, but I think there are indicators of change, and obviously they're to be welcomed.
Thank you, Grainne. So there's more of a comment / question, which I think actually feeds into the next couple of questions. And this is from the Black Child Agenda, who is highlighting a concern. And maybe this is maybe for Kate or Sonali or even Grainne, I know with the education work that you do, the increase of school exclusions, the fact that we know that disproportionately affects children from African, Caribbean and mixed race backgrounds. And I think the impact that kind of COVID-19, etc., will have on, and I suppose mental health will have on school exclusions. The next, I suppose, question, perhaps that maybe Sonali could answer is, and Kate, what remedies are available to children whose educational outcomes and development has suffered as a result of the Coronavirus Act?
I think that the most important thing to try to establish is how you evidence that in terms of what disadvantage you can show. And I think realistically, some of these issues, for some people it will have been very acute, for some children it will be very immediate and very acute. But actually, as with many cases, what I foresee is it's going to be a bit of medium term, perhaps not long term, medium term evidence gathering in order to show, and this is the sort of call to the NGOs and also a call to the charities who fund those NGOs to get reports and investigations done, so that then you have the body of evidence that's required to evaluate how you can look at disproportionate impacts on certain communities and certain groups of children with, say, for example, special educational needs or disabilities. So there may well be human rights claims that can be brought further down the line. But I think under the emergency legislation, under the current circumstances, as I said, the courts are reluctant to intervene. But if we're but the JCHR report shows that we can't just keep going, we're in a pandemic, and we have to do all these things. The justification arguments are coming closer to the fore, because the evidence required to justify interference, I think, is greater, and the courts might be more interested in trying to into delving into that. Whereas in the beginning of the lockdown, certainly most, at the beginning of the lockdown, some of the newspaper reports go, "Oh, you human rights lawyers are probably all going to be opposing the Coronavirus Act." So no, actually, we want to protect lives. No one's going to oppose that. But what we do need to do is keep a check on the renewal powers, how long the extension is for. And that's back in the government's own statement of compatibility, as well as the JCHR report. Sorry, Kate, do you want to say anything else?
I only really to add that I don't know at this stage what can be done, but I do share concerns about the high levels of school exclusion. And I know there have been a number of reports highlighting the risk to children who were getting no access to education during the lockdown period, and therefore very vulnerable in many ways. And one of the ways in which they were vulnerable was that exploitation, and were susceptible to being groomed into county lines gangs and leading to their criminality and being sucked into the criminal justice system. And that's something that criminal lawyers should be watching out for, making sure that they make arguments that they shouldn't be criminalised for that if they are picked up by the police. And there was also concern about what happens to the group of children who would have been taking their GCSEs but weren't going to carry on in formal education, what support was going to be put in for training opportunities. So I think that there are real concerns, and the JCHR has really put it back on to the government to address how they are going to meet the needs of these vulnerable groups. So yes, thank you for raising that, because it is a point of real concern.
Thank you. I think there's two more points before Steph closes. And so in the chat, the point that's made is, and the question, that there are impossibly tight timescales between regulations being laid down and actually coming into force. For example, the criminal enforcement powers. And this, to be fair to the police, is probably putting them in an impossible position at times, in both terms of effective and a proportionate approach. I mean, yeah. And it says meeting public expectations to do so. So an example is given that second set of regulations were laid at 3 p.m. and they were before coming into force at 12:01 the next day. And the question maybe for Joe or Miranda is there a precedent for legislation which such fundamental civil liberties consequences being brought into effect with so little practical notice?
I saw Joe and I were both shaking our heads there. No, to my knowledge, and I'm very happy for someone to tell me I'm wrong, that this is unprecedented. And I appreciate the pressures of a fast-moving pandemic, but I think that argument is getting weaker and weaker as time goes on. It's one thing to say we didn't know what was going to hit us in March, but even just in my own practice, I see judges that I appear in front of becoming increasingly jaded with the government using the pandemic as an excuse for unacceptable breaches of the rule of law. And I think this kind of legislation is part of that. I also think it's part of a broader disrespect for Parliament, for proper parliamentary scrutiny, and for ensuring that legislation is compatible with human rights. And you can see that through Brexit, you can see that through the prorogation case, of course, and it's all of a piece. And I think it's actually exposing something really problematic in our constitution, which is the elected dictatorship, again, to use another well-worn phrase. But sorry, Joe, I don't want to be using up your time.
No, not at all. I couldn't agree more. I mean, even in the aftermath or in the context of world wars and the like, there's never been any use of the powers that are currently being used at the present time, and the speed that they're being used to effectively criminalise huge swathes of the population. As was sort of said in jest at the beginning of this by Steph. But unfortunately, it's truer than we perhaps like it to be. Who knows, for example, what on earth the position will be when we come out of this meeting this evening. It's a bit of a joke, really. And so equally, though, I do agree with Miranda that at some stage there is going to be much greater scrutiny of the use of delegated legislation for this. And the coronavirus excuse, and one can see why it was so potent and powerful at the beginning of the outbreak, is really wearing very thin indeed. So not least because, of course, one looks at where the government is prioritising different things. So no, in short.
Thank you very much to you both for that. And the final question, which is for Sonali, Kate and Grainne, and maybe even Steph could chip in here, is from our wonderful colleague in Chambers, Emma Fitzsimons. And she says she's wondering that given the developments this week with tier 2-3 areas like Greater Manchester and the lack of good faith negotiations with local authorities, whether you think we might see a greater internal legal challenges between central and local government and the devolved settlements. I think that's a very big and juicy question to end with.
I mean, there's certainly capacity for that, and there's the risk, of course, as you can see from the sort of metropolitan areas, is the political difference between some of those areas and the central government. I mean, that's so where it should be a political it should be a legal challenge or a legal consideration. It does risk being blurred into something different, and I think lawyers will do well just to keep an eye on the law and try to steer out of that political conflict.
I was just going to mention on the question of devolution that I think Joanna Cherry in the Scottish National Party has already raised this, and there was also at least mention of a pre-action letter being sent in Belfast, although I haven't been able to find out what happened to it. But I think it is worth reflecting when you think back about everything that we've said, that there is I think evidence of a strategy to enhance power to ministers and to the executive, and we see it with a pullback on devolution, the reduction of scrutiny for Parliament, and a move and the sorts of move away from rule of law based legislation in the Internal Markets Bill. But I think on devolution, there's likely to be trouble ahead, both politically and also in terms of legal challenges.
Thank you very much. I think that's all of the questions, but just kind of before I hand over to Steph, Kate makes a very good point in the chat where she says the JCHR raised concerns about this in their report, and there's a section on statutory instruments, and it's definitely worth a read.
Thank you. Thank you very much, Ubah, and thank you for your questions and contributions. So I have some notes. I'd started off by saying how to describe the impact of the rule of law as perfect storm. But then again, as the discussion went on, it seemed to me that phrase is not even appropriate. And we're perhaps here looking at something like a shock and awe situation. The gravity of the multiple threats that there are to our basic constitutional rights, whether that is through the upholding of the rule of law, through parliamentary accountability, through the ability of judges to regulate and review and control executive action, and lawyers being able to advance the rights of their clients, all face unprecedented threat from the legislation and the practice that the government is bringing through, whether deliberately, as we saw at the outset, or through the effects of the coronavirus regulations and the manner in which the government seeks to implement it without effective parliamentary scrutiny, and in a way in which courts are going to be told in no uncertain terms, hands off, this is our area. So that context is, I think, one where we would and could only have confidence that this isn't going to continue if we had a government willing and showing itself capable of acting in the national interest. We heard many times as a justification for all of the measures that were taken that we were all in it together. What is absolutely apparent and has become more clear day by day is that there is no sense of in it together, that we are seeing a combination of measures that is disproportionately adversely impacting the most vulnerable and disadvantaged in our society, whether that's on the basis of your social class, whether you're poor, whether you are Black or from an other ethnic minority, or whether you're a woman. and a child, all of those protected groups have been disproportionately disadvantaged by the measures and the manner in which they have been implemented. And I think it was right when it was said, you have to look at this in the context of the previous decade of austerity, the impact that that has had, both in terms of the poverty of our citizens and the inequality within our country, as well as the dramatic undermining of our public services, whether that is the health service, but also, as we heard very eloquently, our criminal and civil justice system. So that does seem to me to be a circumstance in which lawyers have the biggest challenge that they have faced probably for at least a generation, if not beyond. We all have to rise to that challenge, whether it's in being doing what we do best in terms of bringing cases and succeeding to raise those issues in the courts, and by doing that also in society at large, and of course engaging in a way that some do, many who on the panel, in fact all on the panel, and many who've participated in having a voice outside of the courts in articulating what are clearly very major concerns for those that we seek to represent, who are disadvantaged in particular by structural discrimination within our society. And certainly the attack on lawyers in that context can only be met by standing up for what we do. We have a motto at Garden Court. Sometimes I feel a little bit embarrassed about it because, but it really rings true for this context, and that is do right, fear no one. And that's the minimum that we really need in challenging and meeting the challenges that our society and we as lawyers face in the justice system. So I hope that you've been enlightened by the scope of the challenge, and also inspired to look for ways to bring legal challenges as one part of our separation of powers that can, and I hope will, hold this government and its authoritarian tendencies to account. And I think that will bring this session to an end, no doubt. I hope will be followed by other topics, and that you'll participate in those as well. Thank you very much.